everybody. It's so nice to see you. This was a very highly registered for webinar, so we're so excited to get it going. I'm Tracy Wheeler with Savvy Ladies. I'm going to put in the chat a link to our one-on-one pro bono helpline. If you have personal questions, we encourage you to come to the helpline. So without further ado, we have 3 volunteers speaking today. We have Mark Prendergast, we have Michael Reynolds, and we have Michelle Petrowski. And they are all going to just speak in succession. So we'll kick it off with Mark. And if you have any questions, go ahead and put them in the chat. And while they're not speaking, they're going to try to answer, but we're going to leave some time at the end for Q&A. We are on a meeting format, so if you don't mind just keeping yourself on mute, we love to see your smiling, happy faces. So being on camera is wonderful. Just keeping yourselves on mute, that would be great. So let's get it started. Thank you for being here. Take it away, Mark.
Thank you very much, Tracy. Sound okay?
Perfect.
Okay, do my sound check here. I was having little problems earlier. And Tracy, do you have the PowerPoint slide, or am I supposed to run that from my computer?
I can run whichever you prefer, Mark.
If you could run it, that would be easier for me.
Absolutely. Give me one moment. I have it open. Pull it up here. Ready. And here we go. Oh, now I got to get back to the Zoom screen. The wonders of modern technology. We are on live TV here.
Right. I'll just start by a little bit of a self-introduction, and when it pops up, we'll start moving. There it goes. So I am Mark Prendergast. I'm a CPA and a certified financial planner. And I'm with a firm called Inspired Financial in Huntington Beach, California. My job, I am director of tax strategies. I do tax and estate planning within our firm. Other people do the financial planning and investment management, et cetera. My hands don't even touch that. So I'm here to talk about what is estate planning. And this is really at the very highest level. I'm going to try to get this in 10 or 12 minutes, something like that. And so we can move through all the speakers. And Tracy, next slide, please. And as a broad view, what is estate planning? And to me, it's ways to reduce the various types of friction. And so what is friction? Friction to me in estate planning, the most important is family issues. Money can cause problems in a variety of ways. And we'll talk about family issues and how estate planning, how we try to avoid those negative family issues. Income taxes also plays, when we're thinking estate taxes, how does income taxes play into that? So we're going to talk about how estate planning plays into income taxes a little bit. And then the third is estate taxes, which what everybody thinks we're talking about, but most people don't even get into the estate tax realm, because you have to be worth today like over $13 million before you have estate taxes. But we'll talk about that, and then about the friction that happens within estate administration, which is time and costs predominantly. So we'll dive into the next slide, talking about family issues. So a lot of times somebody will just name the eldest child as the executor or a successor trustee. And oftentimes that's not the best person. And sometimes it doesn't matter which child. You may say, oh, well, Mark is a CPA and maybe he's only second in birth order, but maybe that's who should be the executor. But that might not be, what happens when my sister Debbie comes to me and says, oh, Mark, I need some money right now. Can we distribute this stuff a little faster? I have a car payment to make, a mortgage to pay, or tuition to pay for my kids, whatever it is. Now I'm in a situation where I have to do what's prudent, and I have to tell my sister no. Or you may have siblings that has some substance abuse and all sorts of issues that come up. So naming the eldest child or naming any sibling sometimes is not the right person. We could also talk about, what about naming a sibling, meaning my sibling? What if I name my sister Debbie as the executor? And then my kids are minors, or my kids, we'll say my kids are in their 20s, and the same questions come up. And now all of a sudden it was like, and Debbie and her favorite nephew, Joe. Well, Joe needs some money and wants some money. And so now we kind of just disrupted that relationship. And that's not a good thing. And the third is uneven distributions without discussing with children. So let's say you have a daughter that's a surgeon and she's single, and you have a son who's a school teacher in rural Iowa, and he has 3 kids. And you may think, well, I want to favor my son who is a low earner and has more family obligations. My daughter can take care of herself, and that can be very hurtful to her. If there's a family discussion, and then you and open that up and say, what do you think about things? Or this is what I'm thinking of. And then you can get the children's feelings about that. And if the daughter, who's the surgeon, is really offended, well, then maybe you back off and say, maybe I want to go 50-50. Or, just talking those things through is really important. So family friction is one of the big areas. We'll go to the next slide and we'll talk about income taxes. And one of the things about death that happens, we're talking estate planning, at death, we get a step up in basis on assets. So if I bought Apple stock in 2004 at $10,000 and now it's worth $400,000, I haven't done the math on it, I'm just making these numbers up. But if it's worth $400,000, if I sell it and I die next week, if I sell it, well, I have to pay capital gains taxes on it. If I die holding that Apple stock, then my kids inherit it, or my wife, probably my wife first, but we get a step up in basis, meaning that it's as if they bought it at fair market value on the day that I died. So my heirs can sell it and pay no taxes. Or a key example of this might be more like the family home, where you go, well, I'm just going to give it to my kids. I'm elderly, whatever. I'll give it to my kids now so we don't have to deal with it. They'll inherit it, but I still get to live here and we'll be all A-okay. Well, if the family home was bought in the 1960s, for $30,000, now it's worth $600,000, and kids inherit it. Well, all of a sudden, they would have no taxes to pay if they sell it after I die. But if I give it to them now, they're going to get my basis as if they bought it for $30,000. They turn around and sell, they're going to have capital gains. So working that step up in basis to your benefit. A comment on IRA distributions in estate planning. Number one, they do not get a step up, and IRA does not get a step up in basis. So any future distributions, those are still going to be taxable income. And there are new rules, relatively new in the past couple of years, that the longest you can, for a non-spousal, once you inherit that, you have to distribute it in fully within 10 years. There are some exceptions, but that's the general rule. Generally, if kids are going to be inheriting your IRAs, then they have 10 years to withdraw that. And if you have a large IRA, and let's say you had one kid, you could really be pumping a lot of income into their tax bracket. So there's management over that, over those 10 years. If a spouse inherits the IRA, they can just roll it into the spouse's IRA, and they would have still their normal required minimum distributions. They could stretch it out for their entire life. And annuities, I'll make another comment on those, would be that they do not get a step up in basis, because you basically made a contract with the IRS. I'm going to put money in here, it'll grow tax deferred. Well, if you die, that growth is still going to be tax deferred, and whenever whoever inherits it, the growth, they're going to pay taxes on that. So next slide, please, Tracy. And so now we get to the estate taxes. Estate taxes, the exclusion now is at 12.9. It's actually $12.92 million per person. If you double that, we're talking almost, $26 million for a couple. And a lot of people just ignore it because the numbers are so high. And even if you're worth $5 or $6 or $10 million, it seems like there's no possibility you're going to be subject to estate taxes. However, we have to recognize the law says in 2026 it's going to be cut in half, and it may be decreased further if Democrats, and then I don't care what political persuasion we are, but if the Democrats get control of both houses and the executive branch, they may cut that further. So for very large estates, there needs to be some management done. Annual gift tax exclusion, that's up to $17,000 per year per donee, per person you would give it to. So if I have 10 grandchildren at $17,000 per person, I could give away at $17,000, I could give away $170,000. If it's my wife and I, we can give away twice that, $340,000. So if I'm high net worth, I think I might have to pay estate taxes in the future. Let's say my wife, it's cut in half in 2026, but my wife and I still are going to have $13 million. Let's say our estate might be worth $20 million then. Under current law, no tax. Under future law, yeah, there would be tax. I may want to be decreasing at $17,000 per person, gifting to my kids and grandkids to reduce my estate. And then, I think the freeze and fractionalize that's for very, very large estates. And I'll touch on it just a little bit. Let's say you had a family business that was worth $40 million. I mean, it's a lot of money, but it's illiquid. If somebody dies, all of a sudden, estate tax bill comes in at $40 million. It could be $15 million. And it's like, well, we have an operating company and it says it's worth money, but there's not that much cash. And so how are they going to pay for it? One of the things they could do is gifting it to lower generations. If they gift less than 50%, they get discounts. Let's say they are roughly 50% on a $20 million estate would be about, or business would be about $20 million. If they're going to gift that to the kids, they're going to give 49%, not 50, but I'm still going to use the round numbers. At $20 million, they could get discounts for minority and lack of control. So rather than making a $20 million gift for IRS purposes, it might be a $13 million gift because those kids really can't go have any say on it. The parents gifted it, but with a lot of restrictions on it. So that's a way of reducing it. And now they pushed it down and they say the gift is only $13 million. But we know it's really worth $20 million. And that as that $20 million grows, it's outside of my client's estate. It's down in my kid's estate. So that's for very, very large estates. So we'll move to the next, and I think final slide. Estate administration and costs. This is another friction point. And in California, that's where I am, revocable living trusts are the almost necessary estate document rather than a will. And I know we have a number of clients in New York, and the estate attorneys say a will can handle this fine. Yes, the probate process is not all that cumbersome. For us, it's very, very cumbersome. So, but it's not just, check my notes here. It's not just the cost of probate, though. Another reason you might want to have a revocable living trust is to avoid delays. You have a successor trustee can come in and they can just start taking action immediately. They don't have to wait for court approval. And another large item is privacy in the probate proceedings. It's a public forum and a public record. And whereas a revocable living trust, you aren't in the probate court and you're managing it on a private basis. So trust for minors. So I'll give an example of my nephews. My mother, she died in 1986, and my sister at that time was not managing her life very well. And my mom said, Mark gets half, and my two grandchildren, Debbie's kids, get the other half, 25% each. Well, they were both minors. And there was no provision for a trust or anything. It's just they get it. Well, they don't get it if they're minors. It has to go into a guardianship. And a guardianship is a mess because you have to go get court approval, get court accountings. It's very, very cumbersome. And then the child turns 18 and they get it outright. Here you go, you're 18. And I had nephews that did pretty bad things. Gun running, drugs, stuff, and ended up in prison and worse. So those that's a reason if you're going to gift to a minor or provide for a minor, let's say grandparents providing for grandchildren like my mother did in not such a good way, a trust would be a good way, because then somebody has oversight and can distribute money out, on a prudent basis, and hopefully not let that child hurt themselves at age 18. And then beneficiary designations in the estate administration is very, very important also, because anything that has a beneficiary designation on it avoids probate. It passes directly to that beneficiary. So that's the least amount of friction, but it's good to review all of those designations, like on an annual basis. I made a mistake on mine once and left everything, life insurance, all to one child, because we were in the middle of doing some estate, having our trust documents updated. And we said, oh, well, we'll just put Allison on there for, 30 days. And once this is done, then we'll fix it. Well, my wife and I, we actually have a financial planner that we pay, and she was reviewing all of our beneficiary designations and said, is this really what you want? I'm like, oh, so we make these mistakes. Review your beneficiary designations on all these, make sure that's who you want your money to go to. So with that, we're going to hold questions to the end, and I probably ran longer than anticipated, but I'm going to pass the baton to Michael Reynolds now.
Awesome. Thanks, Mark. I'm going to take over sharing here. All right. Tracy, can you see my screen okay? All right, thumbs up. Thank you. All right, so I'm Michael Reynolds. Nice to meet everybody. Glad you're here today. Sorry, let me close the window that's in my way. I'm a certified financial planner as well. I know solo firm. My firm is Elevation Financial. Fun fact about me, I play the cello. I've got a cello performance degree from college that I rarely use, but it's just fun to have the skill. So I play around the holidays and fun stuff like that. Big sushi fan. I love sushi. It's my favorite food. I play anything with a racket, tennis, pickleball, ping pong. Also a big Star Trek nerd. Some of you may recognize the Enterprise blueprint behind me. And then my website is elevationfinancial.com. That's where to find me. So I'm going to jump in talking just briefly about a few estate documents that kind of go with your estate plan, some supplemental documents that are very important. Mark did a great job kind of just giving a high-level overview of estate planning, just to kind of recap a few points to segue into this. So some of the basic documents that you probably are familiar with are last will and testament, possibly a trust. A will is designed, as Mark mentioned, to basically kind of decide in advance where your stuff goes, where your assets go upon your passing. It can also do things like define guardianship for your kids if you were to pass. And, if you have a spouse or partner, if you're both to pass, who takes care of your kids, even your pets. So a will defines those things. A trust is similar to a will, but has some differences, bypasses the probate process. Sometimes a better fit for people with families, younger kids that are minors, possibly other reasons. So those are kind of your core estate documents as a starting point, as Mark mentioned. There are some supplemental documents that I think are also very important that are sometimes overlooked. People just think about, oh, I need a will. Oh, I might need a trust. And that's kind of the basics. But there's a few documents that I want to review briefly that are also really important. And these are kind of an easier sell. A lot of times, when I'm working with individuals and families, they think, oh, well, we don't have that much stuff yet, or we don't have that much money yet. And, why is a will or a trust important? And while I think those things are important for everybody, it's a little bit of a harder sell sometimes. But these documents, I think, are a little bit easier to kind of see the value, because they really apply to literally everybody, because everybody might run the risk at some point of, being incapacitated and having medical issues that would prompt these kinds of decisions. So the first document is called power of attorney, sometimes also called a financial power of attorney. This is a legal document that lets you decide who you want to appoint to kind of make financial decisions for you if you can't do that for yourself. The person appointed is called your agent, or sometimes attorney in fact, and they make decisions for you about your financial matters if you're not able to. So things like possibly paying bills for you, communicating with your bank, transferring money, basically kind of managing your financial affairs because you're incapacitated and not able to. There are different types of powers of attorney. There's things like durable power of attorney, which kind of goes into effect immediately long-term. There's other types of powers of attorney that are called springing powers of attorney. They can go into effect upon your incapacitation. Kind of pros and cons, depends on your situation, but that's a little beyond the scope today. But just generally, this type of document is designed to assign someone to make financial decisions on your behalf. And it goes into effect typically when a medical professional, like your doctor, determines that you can't make decisions for yourself. You might be unconscious. You might be in a coma. You might have a serious illness where you don't have the mental capacity to make these decisions for yourself. And so that medical professional can help determine that, which can then kind of activate the necessity for this power of attorney document. So again, I kind of call that an easier sell because whether you have, a lot of assets and a lot of wealth or not much at all, doesn't really matter because you want to have these general details of your financial life handled if you're not able to. So the document is, there's lots of ways to get these documents prepared. The best way is always to talk to an attorney, obviously. But there are some, online services with templates that you can pay a one-time fee and get some designed for your situation as well. So lots of ways to get them done. But the important thing is you want to have those documents executed properly. Typically, they need to be signed, witnessed, sometimes notarized, depending on the laws of your state. So every state has kind of different guidelines for that. So, look up the laws of your particular state and see what the proper execution process is for these documents. Next, I'm going to talk about healthcare power of attorney. This is number 2 out of 3 I'm going to talk about today. Healthcare power of attorney is similar to a financial power of attorney, but it's focused on healthcare decisions. Sometimes this is called a healthcare proxy or a medical power of attorney. Again, it's a legal document, allows someone that you can appoint to make decisions about your medical care if you can't. So that healthcare agent or that proxy is responsible for those decisions, based on what you've decided and what's in your best interest. Again, goes into effect in a similar way when your medical professionals decide that you're unable to make those decisions for yourself, unconscious, coma, mental incapacity for whatever reason. And you can specify the types of medical decisions they can make. Things like, do you want life-sustaining treatment? What kind of pain management do you want? What kind of medical care? What kind of extraordinary or basic measures do you want implemented if you have kind of a crossroads or a decision to be made about your health? And you can specify limitations. So both the financial power of attorney and the healthcare power of attorney both give you the option to specify in detail what specific things that agent has power to do. So in the case of a financial power of attorney, you could specify everything. They can do whatever they want with your finances, or you could say, hey, they can pay bills, they can transfer money, but they cannot open new accounts, or you can really kind of get fine-tuned and detailed about that. So same thing with the medical power of attorney. You can say they can make certain decisions, but other decisions I'm kind of predefining, and I don't want those questioned or negotiated. So those are kind of the differences and similarities between these two types of power of attorney documents. And then as a supplement, looks like it didn't advance. There we go. The Living Will or Advanced Healthcare Directive, as it's sometimes called, is kind of a blueprint for what your medical wishes are if you can't make those decisions. So again, similar legal document, outlines your wishes for medical treatment. So you can specify things like, hey, do I want life-sustaining treatment? Do I want pain management? Do I want intubation? Do I want, DNR, do not resuscitate? Those kinds of things you can define in this document. So again, it goes into effect when necessary, when you can't make those decisions, and it's a guide for doctors and loved ones. So it kind of goes in tandem with your healthcare power of attorney. So it's a guiding document that helps your medical power of attorney make the decisions that would be in alignment with your wishes. So that document is supplementary and very important as a guide when it comes to your medical care. So those are the 3 documents that I'm going to that we're touching on for this segment. And just kind of as I wrap up, a note on, once you get them executed, get them notarized, witnessed, whatever your state determines is necessary to make them legal. You want to store them in a safe place. I like to store them, as a scanned version digitally in my file system, like Google Drive or whatever vault I'm using securely. The original copies go in a fireproof safe at your home. And then copies ideally would go to those named. So whoever is named as your agents for healthcare, for financial, you would give them copies to keep as well as these documents. So everyone knows exactly what's going on. Everyone's in the loop. Your healthcare team can have these documents. Everything's in place and organized. So that's the way you want to make sure they're organized and stored properly. So All right, so with that, I know we're leaving questions to the end, so I'm going to also turn it over to Michelle for our next segment.
Hi, Tracy. Actually, I sent you my updated one. Would you be okay running it, or would that be okay?
Absolutely can. Let me find it.
Yeah, it seems easier. Thank you. So
No
my name is Michelle Petrowski. I'm a certified financial planner. I'm also a divorce financial analyst. And this is a topic as a single mom, divorced, in a committed relationship that's really important to me. You know, at this point in my life, I come across so many women that either are in struggling relationships or maybe they're divorced or widowed. And when we don't have a partner that we can really count on, it's so important that we're knowledgeable about these topics so that we can really protect, you know, ourselves and our families. So were you able to
Almost
get it, or want me to do it?
almost.
Okay. Oh, thank you. And I'm sorry, I did ask you last minute. After I saw Mark do it, I was like, you know what, that's easier. Okay, so we can just go to the first slide, this one. So we're going to just talk about wills, and we're going to talk about revocable trusts. And my two co-facilitators before me did share and touch upon some of those. And we're going to just talk a little bit more about it, like when is it, what is covered, when do I choose it, maybe some other terms that we haven't discussed so far, some benefits, maybe alternative suggestions, and maybe some pitfalls. Okay, next slide. So that will really allows us to decide who gets what when we pass away. If we pass away without a will, it's called dying intestate. And now we're kind of subject to whatever those laws are in the state that we live in. And they can be different from state to state. And so you might want to have a will if you have assets of any value that you really want to pass on to somebody else. You might have a significant other. I think particularly if you're unmarried, this becomes really important because there aren't rights that will be automatically established for your committed partner if you're unmarried. If you have children, this can be a place where you designate who that guardian is going to be. And you might want like a contingent guardian. You know, God forbid something happened or time passes on and that original couple that you talked to, maybe they can no longer take on that responsibility. So you want to kind of like think ahead. We might have dependents other than our children and our spouse. Maybe there's parents or others that we're also taking care of that we would need to address in our will. And the will kind of talks about what happens at that point in time. When I pass away, what happens now? And so if we really have no intention of controlling the distribution of those assets beyond the grave, then the will is a great idea. If not, then the trust is maybe a way to go. And we'll talk about that a little bit. And Mark made a really great point about guardianship and children and why having control past the grave would be really important. Also, okay, next slide. We'll go. So it gives us control. We get to decide, right? Because we don't really want the state deciding what happens and who gets what. They don't really know the most about our life and what's important to us. And so having that will is at least the foundational point to start to have that conversation about that. It allows us to leave gifts to our family members, maybe to charity. It helps our family to grieve. I mean, my mom just passed away, and who wants to now start, you know, figuring out who's going to get what, and there are going to be family arguments. So I'm not going to say that the will gets rid of it, but it definitely can help to create that foundational understanding of what's going to happen at the next point. Somebody can contest it, and there could be issues around that too, but at least it's more structured than having nothing in place. You know, and it really allows us to create that protection for our loved ones financially and emotionally. Let's see. I'm talking about control. I think guardianship, especially when we have children, is a really important thing for us. So whether we're using the will or we are using the trust, we definitely want to address that. You know, no one would want to have the court step in and assign guardianship, you know, to your sister who's an alcoholic that you never would have chosen to have guardianship of your children. Okay, next slide. Okay. So the guardian, we talked about that, special gifts. When you have a will, it's important to have a disinheritance clause, because you could have someone that comes out of the woodwork. It could be a spouse, a sibling, someone that says, hey, what about me? And so you want to address that in your will. If you're working with a professional, of course, they're going to point these things out. But if you're trying to do it on your own, which I don't suggest, you just want to know, you want to address that on some level, that there are people that you're intentionally disinheriting. Sometimes you're leaving them $1. You might tell them that if they take it to court, they get nothing. There's a clause in there, sometimes called a pour over clause. And if you don't have a living will, or if you do, you can use them in conjunction. And whatever you don't have can become a trust at your death. And then that gives you a little bit more control after your death. And we'll talk about that in the next segment. Probate is that process when we pass away. If we don't have a will, it's going to become more time consuming, and it's a lengthy and costly process. If you have the will, it at least creates the foundation for what's going to happen, and it cuts down some of those costs and time. Intestate is when you die without the will. We talked about estate tax, executor. Most folks want just what we call a simple will. There are also things called holographic or handwritten or oral wills. Some states recognize them, most don't. I wouldn't suggest doing that. A mirror will is where a couple is addressing each other in there, but it allows flexibility of one spouse to change something after the fact. A joint mutual reciprocal will is kind of like set in stone, and there's less flexibility with it. Okay, let's see. Next slide. Okay, some of the pitfalls. If you have a will, you definitely want to talk about this with your children and your family. The last thing you want to do is pass away, have them read it, and get really upset about what's in there. The whole point of the will is to lessen that stress and aggravation after you pass away during a time when your family is grieving. This actually just happened to me and my own family. My mom had a will. I was the executor. My sisters knew, but what she didn't do was she didn't give me the original copy like 15 years ago, which I had asked her. She insisted on keeping it. We just had a situation. Her husband moved her out of state intentionally, and he actually stole the will so that my mom would die intestate. And he took her to Florida, which has different rules than Arizona does. So even though my mom was really careful about her estate planning and inheritance, her husband took her to a place in Florida, which they don't really recognize inheritance rules in other states. They have something called an elective share. And so by him taking my mom's will and stealing it, he would get 50% of everything, and he knew that. So I had to track down the original attorney who was not on the will. God was definitely with me on that one. I found the notary, I found the witnesses. We're still into it 6 months, and it hasn't been settled yet to even consider it the original one. We just got a commissioner. So share with your family, don't hide it. It's not a secret. One thing you want to avoid is, I have a typo here. I sent her anyway. If you have guardians, you want to try to avoid co-guardians. So let's say I want my sister and a husband. I might just want to name my sister, because what if my sister and her husband get divorced at some point? So I can name my sister Danielle as my first guardian, and then I can say Donna is going to be the successor or contingent guardian for my children, but I'm not going to put their spouses in there in case something happens later on. And we know 50% or more of marriages end in divorce, so it's just what happens. Beneficiary designations are very important. Many assets pass by beneficiary designation. And so a lot of times, particularly in divorce, I see this, people think, well, I have a will, I'm good. Well, guess what? Your life insurance has your previous spouse on it. Maybe your IRA does, your pension. You die, your ex-husband, wife, they're getting those assets. It doesn't matter that you had a will. So you want to make sure that life insurance, bank accounts, retirement vehicles all have proper designations on them, primary, contingent, maybe even tertiaries. I just mentioned spousal election. So you want to know inheritance rules. I know Pennsylvania also has a spousal election like Florida does. So you want to speak with an attorney about the rules in your state. Make sure if you're going to move, if they're really going to follow what your original intention was. I know there's LegalZoom, trust and will, lots of things like that. I would really suggest having an attorney review it. Legal Shield is a really great product because you actually get to speak with an attorney as well. It's not all automated online, and it's very reasonable. And then a pitfall, research your attorney. Just because they're on a, somebody told you or you found them online, doesn't mean they're great. Go to your bar, look for complaints about that person, maybe go into Facebook groups for if you're a widow or divorced or whatever the case is, now you're thinking about your estate planning. Yeah. Okay, next slide. Okay. Revocable trust. Okay, so the revocable trust is really a way for me to achieve a lot of things. It's a document saying, like, I'm the grantor, so I'm creating it. I create it while I'm alive. I get to manage it. It's really to help simplify the distribution once I pass away, but it also has a lot of benefits. Like we talked about earlier, I believe it was Michael was talking about incapacitation. And so there are two types of trust, irrevocable and revocable. We're just going to kind of talk about revocable. That's really the most common type today. And once the grantor actually dies, it becomes irrevocable, obviously, because now I've passed away. Next slide. Okay. The grantor or the person creating the trust is also known as the trustor or the settlor. They're a beneficiary, so they're like the recipients of what's going to be in the trust. The trustee, co-trustee, successor trustee, that's the person that's going to manage that document, but while you're alive and then after your passing, they're going to they have a fiduciary duty to do what's in the best interest of the beneficiaries. So kind of like Mark was talking about, if you had it like his sister, maybe things weren't going so great, now puts him in an uncomfortable position, like, I still have this fiduciary responsibility. Should I really give this person this money? Is it really in their best interest? Okay, next slide. So the trust is actually, it's a legal document. It helps us avoid this probate process. So you're gonna like go into the probate process, but the fact that you have the trust, it's gonna govern what happens. So it's not gonna be this free-for-all going along with whatever the state rules are. The other thing is it's private. So like if I have a will, and that's what my mom had, anybody can go online and they can go view my mother's will. They can be nosy, see what's in the estate. They could even target maybe the people that potentially are going to be the beneficiaries of that will. So privacy is important. It's simple and cost effective. Now it might be some money up front, to create that, but you're not going to be involved in that whole probate process. I mean, right now, my sisters and I, just to hire an attorney, basically to do nothing, $5,000, right? So the trust could be less. Even if it is $5,000, you're doing it up front, but now you're saving your family a lot of costs later on, because as time goes on, there are going to be more costs associated with this. This isn't going to end at $5,000. It can even avoid probate in other states. So if you have property in other states, you could put it in that trust, and it makes it a lot simpler as well during the probate process. And the family is grieving, so we want to try to make things as simple as possible. Now, there's also let's say adult guardianship. Now, what if I become incapacitated during my life and I can't make financial decisions for myself? I can have something in my trust. My mom or my sister were my trustees. They could then make decisions for me. So adult guardianship, what if I was in a car accident and I couldn't make decisions for myself? And now I had traumatic brain injury or something like that. My family might now have to go through an adult guardian process, which would be really difficult and expensive. I can have it as part of my trust. So it's part of my estate planning, but it also helps guard and protect me against decisions, and helps my family while I'm still alive. Besides just, we're passing things on to family members. What if there's a divorce later? I leave stuff to my children, somebody gets divorced. The trust can help protect those assets. What if creditors come after my kids? There's a lawsuit, there's a bankruptcy. It helps protect my children from a creditor point of view. Doesn't necessarily protect me, but it can have that extra layer of protection. Blended families, people get married all the time. The trust can help set that up to make sure that everybody's getting their share and it's all kind of spelled out nice and neatly, so there aren't any issues later on. Just checking my notes here. Also continuity, right? Someone passes away, there's going to need money for funeral, everyday costs. Having everything that moves more, quickly through probate is going to make it much easier on your family. And then especially, what if you had an estate where there were businesses or there was real estate. Maybe there was you need some continuity of managing of those things, maybe managing other assets. So this creates this continuity without disruption because there's this trustee that's going to take care of this. We don't have to worry about who's going to get things later. Taxes, like Mark pointed out, for most people, it's not really going to make a difference, probably most of us on this call, but it does help remove assets from our estate, which can reduce our estate tax liability for the folks that we leave behind. Next slide. Okay, some of the things I find are that people start a trust and they don't realize they have to fund it, right? So they think it's this thing, it's almost like a blanket that just covers everything they own. But the trust is almost like a person. And so you have to title things in the name of the trust. So if I want to take my house out of my estate, I need to make the trust the owner of it. So I have to actually deed it to the trust. I have to have it recorded at my tax assessor's office, maybe my car, some other things, businesses, LLCs. Maybe people just aren't really clear on when would I have a will or when would I have a trust? How do I pick between the two of them? Again, I kind of told the story before about the beneficiary designations. So if you have those things set up, great. The trust isn't going to override it or the will. And so you want to make sure you're clear on who's really going to get what based on how you have things set up. There's no immediate tax benefit to me if I create this trust for myself, and there's really no creditor protection for me. If I'm looking for something more like that, I would want to do an irrevocable trust. There's a whole other set of concerns with that. So you, again, always want to talk with a professional to help you. And then sometimes folks confuse a living will and a living trust. There's some crossover, like my living will is going to say, what are my healthcare directives if I can't make decisions for myself? The healthcare power of attorney or healthcare successor, sometimes they call it in different states. That would be the person that could make those medical decisions for me, but I can also have that embedded as part of my trust and have that addressed there as well. So there is some overlap there. So you, again, want to work with whether it's your planner, estate planning professional as well to kind of figure out what are the things that are important to you, and then what documents can you get in place to actually achieve your goals. Okay. And I think that might be the end. Oh, okay. Sometimes our state attorney general's office, like I know here in Arizona, they might have basic documents about like healthcare proxy, healthcare directive. There are online services like LegalZoom or Rocket Lawyer. I don't really suggest that. I like Legal Shields because you can pay a fee and then still speak with an attorney. Many employers offer a law benefit. I worked at Schwab Private Client like 10 years ago, and they actually had that. And so I was able to get, all my documents done for a very reasonable price at that time. I've since updated them, but you might want to look into that if you are employed. And then you want to check out your local bar and see what other folks are feeling about the professionals that you're considering. So thank you. That's all I had to say today.
Thank you so much. So there's lots of questions in the chat. I know Mark has answered a few of them. So if the three of you want to take a look at that, and then also if you have a question, you feel free to come off mute and ask it. You can also raise your hand. I'm going to work on the stop sharing here so everyone can see everyone. Let me see if I can clear off my screen a little bit so I can see everyone too. So do we have anybody with a question?
Hi, this is Alicia. I do have a question as it relates to PLDs. So if you have a lot of instruments like CDs or, various financial accounts that have all PLDs, is it necessary to still have a trust?
I guess if those are your only assets, right? I think that's a great alternative to do that at the bank. It makes the money immediately accessible to those folks. And
Okay.
You really want to do some kind of designation on those accounts.
Right, I was just wondering, and also like in my state of Texas, if you designate, not designate, but if there is a, I can't think of the terminology, but pretty much just like a, I can't think of the name of it. You have real estate, and you've already said.
Transfer on death deed.
Thank you.
Yeah.
Yes, and I was just, because that's really, because if you're single, no kids,
Mhm.
that's why I was just wondering the necessary need for a trust versus, a living will, and still having the living will in the will, but is there a need to still do a trust?
Yeah, that's a great question. I'm a big fan of transfer on death deeds where states allow it, because it does allow kind of a clean transfer of property without going through a will or a trust. So yeah, like Michelle kind of alluded to, it's always kind of some trade-offs, some pros and cons. Trusts are a little complicated, a little more expensive, but they have their place. But if you feel that your situation is simple enough and pretty much everything can be handled by beneficiary designations, transfer on death deeds, no minor children, there are scenarios where it could make sense to not do a trust, but just kind of do a basic will plus having all of your beneficiaries, transfer and death deeds really ironed out tightly. And that can be a great alternative.
Yeah, I agree. And we don't really know everything in your situation. So just answering, I think like Michael did at a very high level, you really probably would want to just sit down with someone and just have like a little look over. Does this make sense? Or is there something that you're not thinking about?
Okay, thank you.
Hi,
All right.
for you. I have a special needs child and I haven't done the will yet. Should I go seek a special needs lawyer and then just have them do it all?
If it was me, that's what I would do.
Okay.
And then and point out what you might be missing.
Thank you.
Yeah, that seems to be most efficient because usually special needs lawyers are estate planning attorneys to start with. I'll say as a general rule.
Thanks.
There's a question here in the chat. When is a living trust recommended versus just a living will? And this is always confused me for a long time too. But a living will, they're they have different purposes. A living will is really about end of life decisions. It has nothing to do with your property. So that's the living will. A living trust is like a will substitute. It says where my assets go when I die. It's going to be in trust, but this is how I want it to go. So, so it's not one or the other. And I think a living will or something like that, everybody should do. I procrastinated for years on doing something like that. And I went through something like 5 wishes and I just sat down in front of a football game because I'm just a couch potato for 3 hours anyway. And I said, listen, I'm just going to walk through this thing. And I spent, a good couple hours and it was really evoked a lot of emotion, how I want to talk to my kids and the kind of care I want to have and things like that. So I encourage everybody to get something like 5 wishes. There's another one called It's Your Way. I think that's one I used. And then I gave it to my kids so they know. I don't want them feeling guilty about end of life things. I want them to know what I want and then they can go and execute that without the guilt or conflict between them.
Yeah, I put this in chat just to make sure everybody saw it. A living will is the same thing as advanced healthcare directive.
Yeah. So it doesn't have to do with your property. So that's the distinction. So it's your wishes
Correct.
about maybe your care and things like that at the end of your life, not your assets or your finances.
There's another question says what is a PLD? I think it's a POD is what they were referring to, which is payable on death. It's a beneficiary designation. If it's cash, it's a payable on death POD, or it's TOD, transfer on death. If it's other assets like securities, sometimes real estate. You can in California you can put a beneficiary designation on real estate. And I just learned this in Texas. You can have a beneficiary designation on a car. You have to file something with the county recorder, I believe, something like that.
Yeah, we could do that in Arizona too.
Yeah, I think many states do that.
Maybe you can in California. I just don't know, but I just got educated, so I'll have to find out.
I'm happy to see the poll results coming in with a lot of a lot of folks interested in getting these estate documents prepared.
Yes.
Yeah, great.
Hello, my name is Denise. I have a question.
Go ahead.
So my question is for a vehicle, is like, so for the property of, if you want to leave your vehicle to somebody upon death, is that only, are you only able to do that, with a trust, not in a will?
No,
Either
you
will do it.
will. Or like they were talking about, some states have like a transfer form that you could do and file for your car as well.
And the will would do
Okay,
it, it would
so
just go
you-
through probate.
Mhm.
Oh, so if you only have a will and not a trust, you would go through probate for some of your properties, like
Correct.
the
Anything in the
vehicle?
will goes through probate.
Oh, okay. So that's one of the differences too between living will and the trust, correct?
Well, again, a living will is the same thing as advanced healthcare directive. The living will defines your wishes for medical care if you're incapacitated. So it's nothing to do with property.
Okay, so then for property, you have to do the trust.
Or a will, or like a transfer deed, if your state allows it.
Oh, okay, if your state allows it.
The terminology is confusing. You're not alone.
Yeah, okay, I got
But those
it,
are,
I got
it's,
it.
yeah, it's either a will, a living trust, revocable living trust, or a beneficiary designation. Those are the kind of three primary ways to pass things on to your heirs.
Okay. And I just inherited, I'm gonna inherit my father's home. And I put myself on the deed with him as a joint tenant to avoid probate. Now, do you guys think that was a good idea?
Probably not a good idea because half of that, he gave you half of it and might not get a step up in basis on the half that you already own. And so you get a step up in basis only on the half that he owns. But talk to an estate attorney about that. They may be able to come up with a position where you get a full step up by making the case that it was for testamentary purposes only. He did not really gift you half the home, things like that. I've seen arguments like that made. But talk to an
And you
estate
mean
attorney.
by step up, what do you mean by that's not, that wasn't really good?
A step up in basis means that when you inherit property, it's as if you bought it like on your father's date of death. And so if you sell it the next day, you know, at fair market value, you pay no taxes because there's no gain. But if he gifted you half the house and you end up selling it after he dies, then half that house is half of what he paid for it. And so you may have capital gains to pay.
Okay, so then, you're saying it would be good to talk to an estate attorney to see how we can work that out?
Yes, see if there's a way to kind of technically find a position so that you can undo that. Or just find a way so that you would inherit it with full basis. I don't know if you can or can't, but that's why you have to talk to the attorney in your jurisdiction.
Okay, thank you.
So Mark, it looks like in the chat, some people had wanted to know the second item you mentioned, my way, with a question mark after it.
Oh, yeah, it's something like, it's called It's Your Way, and it's something out of Long Beach, California, and I can't remember the name of the nonprofit that publishes it, but it's similar to Five Wishes.
And it also, we had some newer questions in the chat. Let's see. There's one from Julie that says, if my brother dies before me with no will, he's my only living relative and I his. Would all assets go to me automatically? And would I be automatically responsible for his credit card debt?
Oof. There's nothing automatic. Basically, this is the problem of dying without a will, is that your state or his state defines who gets the property. It may say the living sibling and there are no other relatives. It may, there's all sorts of rules. So you had a bunch of politicians basically made up the state statutes and passed the law, and it says how it passes. So that's what you have to find out. You would not be responsible for his credit card debt, but if he has assets, then they may have claims on the assets. So in essence, you may have to pay for it out of the assets that you inherit. Maybe. Again, that's where you need to talk to an attorney.
I think we might have covered most of the questions in the chat. Is there any other questions? Anybody want to come off mute?
Tracy, it's Sharon. I'm just going to reinforce the beneficiary issue. I knew a couple who lived together for many, many, many years. They split in their 70s. The guy never updated his IRA, and she got everything, and his children got nothing from that IRA because he just never updated it.
Agreed. Review them annually.
That is so important.
I worked with the military for a number of years, and we had a member that passed away, 3 kids. He never changed the beneficiary and his $500,000 life insurance policy through the military. It was his girlfriend from high school. And so his wife and the kids got nothing.
His girlfriend was pleasantly surprised.
I'm sure she was.
Yeah,
That's just an
so so in January we had thought, Savvy Ladies had thought about, you know, launching that whole series, or we did do some of it, but launch the whole series on renewing and rebooting your budget and rebooting your insurance policies. So, you know, pick that time of year to look at your beneficiaries, look at everything, protect yourself. These are your assets for your family, your legacy. So it's really important to do that. We are right at the hour. If anybody, we probably take one last question. Does anybody have one last question?
I would like to know, what do you suggest talking to parents about this stuff? My parents are in their 80s. I know they have a living will. There is a trust, but I can't get them to talk to me. And it's like my dad's controlling everything, and it's been very frustrating. And I just wondered if there's any tips for any of that, or a suggestion about what they should be doing at 80 versus maybe 60. And there are no grandchildren.
So why don't you tell them the story that I told you about my mom, and tell them that, you know, that you love them. And when they pass, it's going to be so difficult that you're going to be grieving them. And the last thing you want to do is, I don't know if you have siblings, is be in the dark with your siblings and having to figure all of this out. And so if we could just really have a loving conversation from the beginning, you know, you care about them. It's not like you're hoping they're dying and you want to know what you could get. You just want to make sure that you're all on the same page, so that when you are grieving, you can get through it as quickly as possible and be supportive of each other, because they're going to be gone.
Thank you.
It is a very, very difficult situation. And I think that's generational too, where dad controlled all the purse strings, and it's just difficult.
Yeah. My mom had stage 4 cancer. We knew she was going to die in a couple of months. And every time we tried to talk to her about it, she was like, "What are you trying to kill me?" We were like, "No, we're not trying to kill you." And it wasn't until like the very end, honestly, that we could get her to talk about it. So I do feel for what you're going through.
Thank you for bringing that up, Kelly. That is one of the more difficult things. And even when you think of ourselves now as parents, and even if you have younger children, keep those lines of communication open. It's really important. Again, if this is your legacy, this is all, you know, what you're leaving to your children. So I always think it's really important. I mean, I have a 17 and 15-year-old who don't really want to listen about it, but we do talk about it. So it's really great to start early on. So, well, thank you all for being here. And I want to give a great big thank you to Mark, Michael, and Michelle, the 3Ms. They did a great job. Thank you so much. And we are going to have the recording available if there's anything that you had wanted to review. Again, please come to our free financial helpline. All 3 of our speakers today are volunteers. We also had some other volunteers that were on as well. So definitely check out our brand new Savvy Ladies app that you can download in the the App Store and Google Play. So we're so excited for that. And on that note, we will go ahead and close. And again, thank you so much for being here.
Thank you all for coming
Everyone.
and having us.
Bye-bye.
Bye.